Dwight's hiding out.
How do I get a logo when I go mute? Nice logo, Dwight.
You can thank Brett's dad for that.
Let's go there. All right. Come on, computer, where you at? All right, let's be on the record in case number 2020-CR324, captioned State of Kansas versus Travis S. Kelley. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears virtually through Assistant District Attorney Adam Sokoloff.
May it please the court, Mr. Kelley appears in person via Zoom video with his counsel, Dwight Alexander, via Zoom video.
All right. Mr. Kelley, as the lawyers have mentioned, we're doing this by video conference due to the pandemic. My understanding is you've had a chance to talk to Mr. Alexander. You want to waive your personal appearance in court and do this by video conference. Is that correct?
Yes, sir.
All right. As I said, we're set down here for a plea today. In order to take up your plea, I need to ask you a lot of questions. And to do that, I need to have you sworn in. So if you'd raise your right hand, my court reporter will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
All right. Before we started, Mr. Kelley, we talked to your lawyer and the prosecutor, and my understanding is that in order to get through this plea today, that you want to waive your preliminary hearing. So I'll ask you, you know what a preliminary hearing is? Do you want to waive it, or do you have any questions about it?
No, sir.
Okay, you want to waive it?
Yes.
All right, and Mr. Sokoloff, on behalf of the state, you waive prelim?
State waives, Your Honor.
All right, I'll find that both parties waive prelim, bind this case over for trial, and enter a plea of not guilty on behalf of the defendant for the time being. All right, like I said, I have to ask a lot of questions. If you don't understand something I ask you, stop me and let's talk about it so we make sure we're on the same page, okay? If at any time you want to talk to Mr. Alexander, you just let me know. We'll send you guys out and you can talk to him in private, okay?
All right.
All right. How much formal education you have, Mr. Kelley?
Ninth grade.
All right, you read and write okay?
Yes, sir.
As you sit here today, you're under the influence of any alcohol or drugs or prescription medicine that might cloud your thinking?
No, sir.
Feel like your mind's clear, you understand what's going on today?
Yes.
All right. You understand what you're charged with?
Yes, sir.
Do you know you don't have to change your plea to plea of guilty today? If you wanted a jury trial in this matter, you'd have an absolute right to that trial. You understand that?
Yes, I understand.
All right. If we had that trial, the state would have to put on enough evidence to prove you guilty, and you wouldn't have to prove beyond a reasonable doubt. You wouldn't have to prove anything yourself. You understand that?
Yes.
At that, lawyer, Mr. Alexander, would get to confront and cross-examine all the witnesses against you. He could call any witnesses you wanted called. If they didn't want to come to court, he could use subpoena power to make them come to court. If you wanted to testify, you'd have that right. But if you didn't want to testify, you would also have the right not to testify. And if that's what you decided, the state couldn't use it against you. In other words, Mr. Sokoloff couldn't get off and say, ladies and gentlemen, he must be guilty. He didn't tell you his side. You understand all that?
Yes, sir.
All right. Now, if it went to trial and you got convicted, you'd have a right to appeal that conviction to an appellate court. And if you didn't have money for that appeal, a lawyer would be appointed to do it for you. You understand that?
Yes, sir.
All right. Now, if we go forward with this plea and you end up pleading guilty, there's not going to be any trial like that at all. You're going to be giving up all of those rights that I just went over. Do you understand that?
Yes, I do.
Any question about any of those rights at all?
No, sir.
All right. And are you wanting to change your plea today to one of guilty?
Yeah.
All right. Now I'm going to show you here on the screen the plea petition in this case. I want you to take a look and tell me if you recognize this document.
Yes.
All right. Did you and Mr. Alexander have an opportunity to go over this whole document?
Yes, sir.
Feel like you understand everything in it?
Yes, sir.
Would you agree with me that it's basically goes over kind of the same rights that I just went over with you?
Yes, sir.
All right. Now down here where it talks about the plea agreement, it says that you're agreeing to plead guilty to the amended information that has one count of aggravated assault, a severity level 7 person felony, and one count of criminal threat, a severity level 9 person felony. The state's not going to ask me to find that you committed this crime with a deadly weapon, and they're going to recommend probation and the standard underlying sentence with concurrent sentencings. Is that your understanding of the whole plea agreement?
Yes, sir.
Anybody promised you anything else other than what I just read to you to get you to plead guilty today?
No, sir.
All right. Mr. Alexander, is that your understanding of the entire plea agreement?
It is, Your Honor.
And Mr. Sokolov?
Yes, Your Honor.
All right. Anybody, Mr. Kelley, put any force or threats or made pressure you to get you to plead guilty today?
No, sir.
All right. On this plea petition, it talks about the maximum sentence. Okay, I know that Mr. Alexander and you have gone over what you expect your criminal history to be and where that would leave you with sentencing. But you understand, for today's purposes, I have to assume that you have the very worst criminal history so that I can advise you of the maximum sentence that anybody could get for this crime. Do you understand that?
Yes, sir.
All right. So the maximum, and I take it, Mr. Alexander, you added the maximum of the 7 and the 9 to come up with this 41?
That's correct, Your Honor. Aggravated number in the 7 and aggravated number in the I box of the 9 to get to 4.
All right. So, Mr. Kelley, the most that anybody could get for pleading to these two crimes would be 41 months in prison with 12 months of post-release and a fine of $100,000. Do you understand that?
Yes, sir.
All right. Now, I also read in that plea petition that they're making some recommendations about what your sentence should be. You understand, I'm going to listen real closely to what everybody recommends to me, but I'm not bound by any of these agreements between the state and your lawyer, and I can give you any sentence that the law allows. Do you understand that?
Yes, I do, sir.
All right. So before I take this document down, I want to show you this. Well, there's not a signature. Mr. Alexander, did you send a different copy to the defendant for him to sign? You're muted, Dwight.
Judge, I just sent the original copy to my client for us to review together via the team's jail visit. What I have been doing is just asking the court to allow for my client to basically electronically sign the document because I, wasn't able to physically get into the jail and hand it to him in order for him to sign.
Right. All right. So, Mr. Kelley, at some point, you're either going to electronically or actually sign this document. Is that correct?
Yes, sir.
All right. And Mr. Sokolov, Mr. Alexander, you've both reviewed the petition and approved the same?
Yes, Your Honor.
Yes, Your Honor.
Okay. All right. So, Mr. Kelley, Mr. Alexander's represented you throughout this case. Are you satisfied with his advice and counsel?
Yes, I am.
Any complaints about the way the courts treated you?
No, sir.
All right. So before I ask you how you plead, do you have any questions about anything we've talked about today?
No, sir.
All right. And Mr. Alexander, do you know any reason why Mr. Kelley should not plead?
No, Your Honor.
All right. Given that, Mr. Kelley, as to count 1 of the amended information charging you with aggravated assault, a severity level 7 person felony, how do you plead? Guilty or not guilty?
Guilty.
As to count 2 of the amended information charging you with criminal threat, which is a severity level 9 person felony, how do you plead? Guilty or not guilty?
Guilty.
All right. I'm going to ask Mr. Sokoloff to tell me what he thinks the evidence would be if we went to trial. I want you to listen closely because at the end of it, I'm going to ask you if that's what happened in this case. And I'm sure he's going to be careful not to allege that a deadly weapon was used in the commission of this crime. With that, Mr. Sokoloff.
Yes, Your Honor. And could I ask the court to unshare the screen so I can access my documents?
Yeah, sorry about that. There you go.
And there may very well be a way for me to do that without you doing that, Your Honor, but I'm ignorant.
No, I always mean to take them down and forget to do it.
Well, Your Honor, first of all, I will obviously give a rendition of the facts in this case that we believe would be consistent with the plea. And also I would point out that if the court felt there was some inconsistency, that the benefit of the bargain here is towards the defendant, and any factual discrepancy or legal fiction would of course be permissible under that framework, which is benefit of the bargain to the defendant. Also, I would note that the case law suggests that the state has to ask or a judge has to make an affirmative finding of a deadly weapon, regardless of what the facts were presented. And we are not going to ask the court to make said finding today. So I will still be careful with my language, but I don't believe I have to be as careful as I'm going to be. But that, sorry, is a long-winded way of getting to the facts.
Sounds good. If
this was to go to trial, the state would present evidence to the court that we believe would prove that on April 1st of 2020, at the location of the 5100 block of Pitkin Avenue, which is in Wyandotte County, Kansas City, Kansas, officers responded and made contact with the defendant, Mr. Kelley, and that Mr. Kelley had in his possession, that Mr. Kelley had been in an interaction with the victim in this matter, and that during that confrontation with the victim in this matter, that the defendant brandished an object that appeared to the victim to be a weapon and to be potentially harmful to them, that Mr. Kelley presented said object with the intent to cause that apprehension in the victim, and the defendant saw an object and believed that they were an imminent risk of harm. And that in addition to that physical conduct, that Mr. Kelley made statements intended to communicate a threat to the same said victim here in this matter, and said commentary was heard and received in the same spirit of causing terror or fear, thus satisfying both the aggravated assault and the criminal threat charges to which the defendant pleads on the imminently filed amended information.
All right. Mr. Kelley, you hear what Mr. Sokoloff had to say there?
Yes, sir.
Is that what happened in this case?
Yes, sir.
All right. I'm going to find that defendants freely, knowingly, voluntarily waived his constitutional rights and entered this plea. There is a factual basis for the plea. He understands the nature of the charges, the consequences of plea, and I'll make a finding. He is in fact guilty of the amended charges, count 1 and count 2. Sentencing will be deferred pending a pre-sentence investigation report. I'm looking, Dwight, at a sentencing at 7/17 at 9:30. Take a look at your calendar if you can. Let me know if that works for you.
9:30, you said, Your Honor?
Yep.
That works.
Do you want to do person or Zoom?
Zoom's fine.
That works for, all right, that works for Adam as well. I'll just assume that we're going to do Zoom sentencing. If something changes, I'm available in person. They just want us to do as little in person as possible for the time being. Dwight, did you get a PSI request form filled out?
Judge, I will have that filled out and emailed to you here shortly. I talked to Mr. Kelley yesterday and got all the information, but I just need to put it in the PDF and send it on to you all. So I'll get that done this afternoon.
All right. Get it to me. I'll get it over to probation and make a record of this, setting the date. All right. Anything else we need for our OR?
Yes.
No objection. Mr. Sokoloff, do we need to get him looked at by pretrial, or do you just want me to OR him?
Your Honor, I don't believe that pretrial at this point provides much supervision, and given the pandemic, and he's going to be out. We'll give him a chance to be out. I guess in the next 6 weeks, he better behave.
Yes, sir.
All right. Okay. So just to make sure on the PSI request, does it have good information where Mr. Kelley will be when he's released?
Yes, Your Honor, he's going to be going back to his home. He owns that home, and it is a good address for him. As far as phone contact is concerned, I asked him for the most constant and consistent number, and he provided me with his mother's contact information. So we should be good there.
Mr. Sokoloff.
The only thing, Your Honor, Mr. Kelley seems to be a smart and articulate gentleman and probably understands these contexts. There exists a no contact order. I would ask the court remind him specifically because they are neighbors. They will see each other. There will be close proximity that I believe is unavoidable. And maybe the court could stress the importance of the no contact and what that really means.
I
Okay.
completely understand that.
All right, so here's a few things, Mr. Kelley. Mr. Alexander's going to create what's called an order to release and send it over to me because I don't have one in this case yet. I'm going to sign that. You're probably going to get out today. If not today, at least tomorrow at the latest, okay? He's also going to get me this PSI request form with your information. Probation's going to be reaching out to you, I would guess, in the next week, no more than the next 2 weeks to get you set up for your pre-sentence interview, okay?
Okay.
If you don't hear from them within 2 weeks, you need to light up Mr. Alexander's phone and find out what went wrong, okay? Because we don't want you missing that stuff.
Yeah, I
As
don't,
Mr. Sokoloff said, there's a no contact order with the victim. You coming and going, you guys are probably going to see each other. You need not to have any contact with him. That includes if you're walking into your home and he steps out and wants to engage you in some kind of argument or anything, or you have to ignore him. All right.
yes, sir. I got
Um,
cats on my house too. So,
Okay. So here's the worst thing that could happen. You guys get in some sort of beef and the victim decides to come in and tell me at your sentencing that you're still giving him trouble and all that. And he wants you to go to prison. You understand all that?
I understand, Judge.
All right. The worst thing you could do, and again, it's not even fair because even if he wants to talk to you, even in a reasonable way, hey man, I'm not mad at you. I just want to talk to you. You got to say, my lawyer and the judge says I can't talk to you. When this is all done, you want to talk, I'll be okay with it. All
Okay.
right.
Yes, sir.
7/17 at 9:30 for a sentencing. Dwight's going to get me the order of release and the PSI request. Anything else for our record today?
Just, Your Honor, I plan to have that amended information filed in the coming hours. It should be, just given the us working remotely situation that we don't have a full staff, but I wanted to tell you that it should be filed imminently.
Okay, sounds good. All right. If there's nothing else, we are adjourned, and I'll
Thank you,
stop
Judge.
this.